Everyone, welcome to today's Center for Policy Studies webinar titled Online Safety Bill, Legal but Harmful. My name is Matthew Feeney. I'm the head of technology and innovation here. I am a relatively new addition to CPS. This is my first webinar, and in my first couple of months back in London, I've been tasked with working on the Online Safety Bill, which is the topic of today's webinar. Although we're speaking today in 2023, this has been a journey that's been going on for a number of years, starting perhaps in 2019 with the Online Harms White Paper. And after years of debate and parliamentary procedure, we're finally at a stage where the bill is in the House of Lords. The bill that we're here to discuss today is ambitious. It aims to tackle a range of harms that people around the world have identified with social media and broader technology platforms. Child suicide, harassment, abuse, COVID misinformation, conspiracy theories, and a host of other content that governments around the world have struggled with. The bill is aimed at tackling a lot of these harms by empowering regulators and by imposing obligations on online platforms. But I think it's safe to say that while many people applaud the goals of the bill, it's been immersed in controversy, namely from civil libertarians who have concerns about the free speech and privacy implications of the bill, but also from the business community that have concerns about the effect the bill will have on competition and innovation. And today I'm very pleased to be joined by four panelists who have a range of views on the bill to discuss the thoughts on the bill's potential, the risks, the opportunities, and what we might expect in the next couple of weeks as the Lords continue to scrutinize the legislation. The format of the webinar is going to be the following. Each of the speakers is going to speak for a few minutes, introducing themselves and giving their bird's eye view thoughts on the bill. Then we'll have about a half-hour discussion amongst ourselves before turning over to you, the audience, for a Q&A session. And rather than give a full in-depth introduction to each of the speakers, I thought I would allow them to introduce themselves. And we're going to begin first with Matthew Hodgson from Matrix. So Matthew, over to you.
Thanks very much, Matthew. So yes, I'm Matthew Hodgson. I'm the CEO and CTO of Element, which is a secure communications company based in Chiswick, tech capital of the world. I'm also the project lead for Matrix, which is an end-to-end encrypted communication protocol that we created back in 2014. It effectively acts as an encrypted layer for communication on the internet, democratizing communication, letting people communicate securely. And it turns out that it's very popular with governments because governments like to be able to communicate securely both between themselves and within themselves, rather than sending all of their data to Microsoft or Facebook or Salesforce, Slack, whoever it might be. And therefore, as probably the main sort of champion of end-to-end encrypted communication in the UK, particularly as the UK government is a major customer of ours with the Ministry of Defence and many other bits of the national security apparatus depending on Matrix to communicate, we are very, very worried about the Online Safety Bill in terms of it being a catastrophe for privacy, as well as human rights, as well as, frankly, the UK tech sector. And the key problem that we have with it is that whilst obviously we have a moral imperative to protect children from abuse in real life and on the internet, as well as minimize disinformation, etc., the current structure of the bill requires some scanning of content that fundamentally undermines encryption and undermines privacy in order to spot where child sexual abuse material might be being distributed. And naively, this feels like a great idea, but when you actually look at the technology that would be required in order to scan for abusive material, it just undermines encryption for absolutely everybody. So for instance, say that we banned encryption for kids, and we said that everything that children do has to be able to be inspected by a parent to make sure that bad things aren't happening to them. What happens if they've got an abusive parent? What if you are a child abuser who finds a way to undermine this amazing scanning technology that has just been added into all of our communication apps in order to extract the content that the kids are looking at and go and eavesdrop on the children. Now, having gone and sort of opened Pandora's box in that way, it basically sets a precedent for scanning technology to be installed all over the place in terms of apps or indeed operating systems, as Apple want to do for scanning for CSAM in iOS full stop. It would be compulsory. You wouldn't be able to get out of it. You can't inspect the scanning that it's doing. So who knows, is it looking for CSAM, or perhaps the model has also been trained on national security things? Perhaps if you use words like bomb, is that going to get reported back as well? You have to blindly trust that the model is being trained correctly. And it would literally be using the technology that we have in an iPhone today. So here's my iPhone. I've gone and searched for cow. We've got 9 images that come up. Many of them are obviously cows. Look at the one in the middle, and it's a big black horse. So this is the technology, literally, that we would be using to try to identify abusive material on people's phones. And if this was mistaken as CSAM, it gets, I get on a blacklist and reported back to the authorities. We are literally at risk of creating the worst Orwellian dystopia known to man. The solution in my mind is that you need to investigate crimes, just like in the real world. You wouldn't put a CCTV camera in everyone's bedroom just in case they are abusing kids there. It would be ridiculous. The fact that you can technically do that on the internet doesn't mean that we should. We have to consider it just the same as real life criminal investigations, and infiltrate bad actors, investigate them, take out warrants against them and subpoenas and all that mechanism. You do not blanket surveil everybody's phones for any abusive content and undermine the technology, which would undermine the government, who depend on our tech today, as well as making the UK look like a laughingstock in terms of the tech sector no longer being trustable because fundamental encryption has been undermined in order to scan for abusive content.
Great, thank you. Thank you, Matthew. Next, we have opening remarks from Edina Harbinja. Over to you.
Thanks very much, Matthew. So I am a reader in law at Aston University in Birmingham, and I have been following the bill and writing about the bill and speaking about the bill since the white paper, pretty much the initial one, and the inception of this legislation. I've given testimonies to 4 committees already, 3 or 4 years, and I've written various written submissions. So I've followed the bill's journey pretty much throughout the whole process. And when Matthew, when you asked us about what opportunities do we see, I think as it stands, there are quite a few opportunities in the Lords, in the House of Lords, to improve the bill. So fundamentally, I must say that I have opposed the initial idea of the bill, the duty of care. I still oppose the initial idea of the bill, and I think that the bill is far from perfect and acceptable, but I also think that, being realistic, on the other hand, that the bill will probably pass in some form. So I think there is a clear opportunity in the Lords to do something to improve the bill. And I will not repeat what Matthew has said, Matthew Hodgson, the other Matthew, because I do agree with everything that he said very eloquently and about technology, and that's the clause 110 that raises concern and I think needs to be amended in terms of the concerns about blind scanning and the threat to encryption. I will just note 3 other main concerns that I think could be potentially improved in the House of Lords. The first one relates to clause 18 and the duty to protect freedom of expression and privacy. And I've written to the Communications and Digital Committee about improving this clause. In my view, the clause is really vague. It doesn't promise strong protections of freedom of expression and privacy. The wording is pretty clumsy and odd when we speak from a technical, legal, and human rights perspective. So I have written to propose some amendments to clarify and really state very, very strongly that privacy and freedom of expression will be protected without any caveats that we now see in this clause. Secondly, I think what concerns me is clause 170 as it stands now, which relates to the provider's judgment of illegal content. and the standard of reasonable grounds to infer illegality, which is a really vague legal standard, and a better proposal that quite a few of us have argued for in the recent times would be manifestly illegal, because it would provide assurance for users that, not just mere inferences will mean that their content will be taken down and monitored, but also that there will be a stronger, higher threshold for this content. And finally, of course, what I think the Lords are interested in probably amended is the powers of Secretary of State. And there have been some very concrete amendments that I would support, proposed by Lord Stevenson very recently, about clause 39 in particular, where the power of direction for Ofcom when it comes to codes and modifications would be changed just to power, just to make observations. The Secretary of State would make observations on the codes and modifications rather than giving direct directions and therefore interfering with independence of the regulator. And just to add something very, very new, so we know that the restructure of the cabinet has been introduced, and now we have the Department for Science, Innovation and Technology, the SIT, that will step into the Secretary of State's role, I assume, instead of BCMS. But Ofcom will be sort of torn between the two departments, because they're in charge of broadcasting, and BCMS will still be in charge of broadcasting, and the new department will be in charge of online safety and similar issues. So I think there's also this interesting interplay between the executive and the regulator. And I think we'll stop there and we can explore this further later on. Thank you.
Thank you very much. So next we will have some introductory remarks from Baroness Kidron. Over to you.
Thanks, Matthew. So I'm a crossbench peer in the House of Lords, and I take a particular interest in the question of children and wherever they intersect with technology. And I'm at great pains to say not only on social media. And I think that this sort of obsession with social media has actually missed some of the point of the general issue about how technology is affecting our lives and what sort of interaction we want to have. As a country or as a society run on the rule of law, and whether the exceptionality that they've enjoyed over the last decade is appropriate in all circumstances. I will be tabling amendments. Now, surprisingly, perhaps, I agree with much of what both previous speakers said. I am not for general monitoring. I do think that you have to have processes in place to ensure that you're looking at things that are properly illegal and defined, in ways that mirror laws that we have in other environments. I am very much against the tech companies being allowed to make up what is right and wrong, and I think that we need to have a little bit more oversight of Parliament and regulator. And I'm also very concerned about the independence of the regulator, and I'm concerned from 2 points of view, both the Secretary of State powers, as was already mentioned, but also, the actual practice of the regulator not being nudged around by industry, not being nudged around by government and so on, because they do have an enormous role. I think the other big point I'd like to make, just as a sort of a broadening point, is we're not alone. People talk about the online safety bill as if it was the only bill in the world that is trying to tackle this problem. And actually, we just had the DSA, which has had one big swipe at it, and some of what we're doing is very similar and some of it's rather different. I was in Ireland yesterday, in Dublin, and they've just introduced their own online safety and media regulation bill, and they're looking at how those two pieces of regulation go, the sort of member state regulation against the European state regulation, and then at all of these, in all of it, and in fact, next week going to America to talk about regulation in that context. So I think that when we sort of get up on our high horse, and I say that from all sides of the debate, I think we are slightly forgetting that what is being built here is a global consensus or a global norm or a global settlement about how much we have to say about the operating models of the tech sector. And then maybe my, the other point that I can then make is, I'm really concerned that when we talk about freedom, there are two freedoms that we miss. One is actually, everybody seems to be absolutely fine about, parents looking at children and knocking them out of the digital world, which is actually their entire future, but not so keen on children's rights to participate, to speak, to be heard, in this debate. So I think that one of the amendments I'm actually going to be bringing is to cite children's rights, specifically the General Comment 25, the relevance of children's rights to the digital environment on the bill, because I think one of the sad things about, getting rid of clause 11, which I will not call legal but harmful, because it never had that phrase in it, and the bill never had that phrase in it, and it is the most grotesque idea. But when clause 11 went out, one of the unintended consequences of that is everybody's just made a child online very much more expensive. And making a child online very much more expensive does give a lot of people the idea that they'd like to exclude children, because that's a lot easier. And rather than actually coming to an understanding of how we might live online together, we've created these two very separate groups. So that is one of my concerns. My other concern, and maybe we'll get back to it when we have some questions, is really about what are we talking about? Because most of the time when I'm making amendments, objections, points, I'm talking about the system itself. I have very little worry about individual pieces of material, even children's access to it. And maybe most straightforward way of saying it is, if a child goes onto Wikipedia and looks up bestiality, how to kill myself, pornography, all the things, all the most ghastly things that everybody would like to talk about, prevent children seeing, I think that they have a right. It is their best interest to have access to Wikipedia as a tool in their life, as a collective piece of communication and understanding about the world, than it is, to prevent them on those specific pieces. Here's the difference. After they've done it, they're not chased for 6 months with tens and hundreds and thousands of pieces of information saying, hey, how about more? How about a bit more bestiality? How about a bit more? Actually, I've got a better idea about how you can kill yourself. And that is literally what is happening to children. And so in this debate, and I'm very happy later on as we get into the discussion to actually give some very concrete examples, in this debate, we are not necessarily talking about people's freedom to post things. We might be talking about a commercial company's freedom to hound a kid into their death or into misery of a different kind. And I think that is something that, we need to take a look at. And that is the opportunity of the bill, but it must not be at the expense, of misunderstanding what's at stake here.
Thank you. So last but certainly not least, we have Will Moy. Will, your opening remarks, please.
Thank you. I think the conversation so far has amply demonstrated how difficult it is to have a general conversation about this bill. We all have different expertise in different parts of it, and the bill touches on a lot of things. I'm not an expert in child safety or end-to-end encryption. My specialism is in misinformation, disinformation, and good information. But before I talk about one specific element of that, I'll just make one general point about the bill. When it was a white paper and had a different name, and several secretaries of state and a couple of prime ministers ago, we responded to that white paper. And a point we made was that the responsibilities this bill gives to Ofcom are roughly like giving the police the 10 commandments and asking them to figure out the rest of the criminal law themselves. And it was an extraordinary and remains an extraordinary handing over of power to the government appointed regulator. It's very, very important, I think, as a general point of principle across all of these different domains, that Parliament ensures that whatever goes on through this bill is an open, democratic, transparent process overseen by our elected representatives and not just handed off to an appointed regulator. And that balance does not seem to be clearly there at the moment. What we have at the moment is important decisions that shape our democracy, public health, children's lives, and many other things being made by the leaders of tech companies in California or backed by Saudi money or answerable to a corporate headquarters in Beijing. That is a real threat to our society, and accountability for those powers is a need. But let me talk about a different kind of power and one specific example of something we think the bill should be looking at differently. This is a quote from a BBC News article during the pandemic. The Culture Secretary is to order social media companies to be more aggressive in their response to conspiracy theories linking 5G networks to the coronavirus pandemic. Secretary of State had summoned the internet companies, told them what content they should be taking down off their services, and then released a press release to boast about doing that. And I think that's a really remarkable thing to happen in an open society. And if you don't, I invite you to imagine the same conversation happening about libraries. The Secretary of State has called in the heads of libraries from around the country and told them what books they wouldn't be comfortable having on their shelves. I don't think we would accept that. We have, in recent years, developed the potential, the technology, the reality that all kinds of things that serve the function of private conversations, even if they don't operate in quite the same way, are now subject to oversight. And the question is, how is that going to operate? And during the pandemic, we saw one version of that, was the government summoning internet companies, telling them what should be in their terms and conditions, telling them how they should be enforcing their terms and conditions, and internet companies being subject to that pressure, largely behind closed doors, except for the fact that the government chose to press release it. Now, we think that's a real risk. Now, be in no doubt that information ruins lives. It damages people's health, as we saw during the pandemic. It promotes hate, as we've seen through too many attacks, and it hurts democracy, and is deliberately used by hostile states to try and hurt democracy. There is a real threat, but we believe there should be an open society response to that threat, and that this bill is actually needed to encode that response. Rather than government having the freedom to lean on internet companies privately to influence their terms and conditions and how those are enforced, there should be constraints on the government doing that. If they must do it at all, it should be subject to the rule of law and subject to parliamentary oversight in a way that it is not. We actually think the bill needs to tackle three main threats to freedom of expression. One is the internet companies themselves, who are under commercial and political pressure to take down stuff and not be over concerned about freedom of expression. One is artificial intelligence, which, as Matthew amply demonstrated, is a powerful but far from perfect tool, and its unintended consequences need very careful oversight, and the boasts made about its ability to tackle content in precise ways are inaccurate. And the other is what we call censorship by proxy, government leaning on internet companies to enforce its view of what people should be able to see and share online without democratic oversight over that process. So I think there has often been a version of this conversation, which is we can protect freedom of expression by doing nothing. What I want to argue is that actually we have already normalized censorship on a scale unimaginable to previous generations online. And we need this bill to take action to control that, to say if it is appropriate at all in any circumstances, what circumstances and how that should be overseen, and to restore freedom of expression and protect it against these novel threats of this novel world. And that's an argument I made to the Public Bill Committee and also to the House of Lords inquiry on freedom of expression, if you want to hear more about it in more detail.
Great, thank you all. Thank you, Will. Well, I have a bunch of questions for all of you, but if there's something that one of your co-panelists said that is prompting an immediate question, just let me know in in the chat, and I'll make sure we get to that. I want to go in, I suppose, the order in which you spoke, and start with Matthew. So your comments on the risk to encryption made me wonder about what companies such as the one you work for, as well as WhatsApp and Signal and all these other companies and institutions that sell or provide end-to-end encrypted messages, what options are available to you in the wake in the likely event that this bill is passed? Because you've heard the CEO of WhatsApp, for example, say that they would consider leaving the UK jurisdiction. Is this just hyperbolic ventilation, or is this a realistic threat? What do you think, sitting in the private sector, are the potential risks for those using encryption in their business?
No, I think it's not hyperbolic at all. I think that if this goes through, then it is literally dangerous to not just provide an encrypted communication company in the UK, but potentially any kind of user communication service in the UK, if the acts of the users upon it end up with legal risk upon the executives who run the company. I mean, if you compare it with, so my wife works in banking, and so is very familiar with the regulation that goes on in the banking space. And there it's a very regulated business. And if you start abusing your users and exploiting them and fraudulently doing things with the money, then obviously you go to jail. That's completely reasonable. But in a world where the misbehavior of users ends up with criminal liability on behalf of the executives, unless they have somehow managed to do sort of blanket surveillance in order to impose an authoritarian regime over their user base to make sure that whatever Ofcom says is good or bad on a given day of the week is being exacted on those users. I mean, that's just terrifying. So practically speaking, first, we would need to consider moving base out of the UK, which is a crying shame, because there's a chance that we could actually be a UK tech success story, which is something that the UK doesn't very often have relative to, say, the US. But also it literally puts the UK government and our customers in the UK at risk, because the encryption would end up being fundamentally flawed relative to folks in the US who aren't subject to this sort of activity. And it's completely true, as Baroness Kidron, or can I call you Beeben?
Yes, of course.
So as Beeben said earlier, this is a global question. We've got Ireland with their regulation, we've got chat control in the EU. The US hasn't yet gone down this route. They, I guess, have more constitutional protection on privacy and human rights. But I'm sure they would have a go at it as well eventually. I mean, yeah, basically, we would have to seriously consider moving out. Plus, it puts our customers at risk who run their own communication services. Perversely, the only people who might be able to comply with the regulation are the big tech companies who can throw gazillions of dollars at artificial intelligence scanning and basically build this infrastructure. So you end up playing into the hands and supporting the big tech players who are actually the ones who are trying to be regulated at the expense of everybody else. And the final critical point is that the bad actors will just ignore it. They will just keep using Signal or whatever other unregulated app is out there in order to coordinate their illegal activity. And so it's actually the good actors, like, I don't know, the UK government, who would end up undermined by this in reality. It's very frustrating.
Yeah, thank you. Edina, I know you had a follow-up question for Beeben, but I also have a question for you if you'd rather, but let's tackle the first comment you had.
Yes, please go ahead, and then I think, answer both. And
okay, yeah. Well, I'll throw in my question to you, and then take Beeben's point. So you raised concerns about Secretary of State powers, but given the ever-changing nature of what kind of content people deem harmful or controversial, it seems, don't you think, a little unrealistic to expect that Parliament will every single time a new controversy emerge have to pass primary legislation in order to allow Ofcom to address it? Presumably, the Secretary of State needs some degree of flexibility in the legislation as written. Or am I misunderstanding your concern about Secretary of State powers?
I think so. So my concern is about the Secretary of State powers to give directions and modifications of the code, as well as set strategic priorities for Ofcom, which in my view and in view of the theory and scholarship around regulatory independence is a unnecessary and unhelpful interference with the independence of the regulator that, you know, the bill gives power to without then the legislative oversight. Of course, there will be flexibility, and Ofcom has a lot of flexibility in how they design the codes and implement the bill. But I don't think giving flexibility on grounds on, for example, public safety as a very broad term would help this and prevent abuse of executive power that we are concerned with. And if we remember of the recent statements about banning videos of boats crossing the channel, we really have some grounds to believe as to the intentions of secretaries of state. My comment on Baroness Kidron Bevan's contribution was actually about this dichotomy between systems and content, and the fact that we are focusing a lot on content instead of systems. In principle, I do agree the systems, in particular with protection of children, manipulation, dark patterns, and a lot of other technology that is misused by the big tech companies is a concern. But Bill does tackle content on a very large scale, and we can't really we can't avoid that. Most of the bill talks about content, user-to-user services, and the content shared between users, offenses related to that content, priority offenses, criminal offenses, how the service providers judge this content, what do they have to do about content. There are provisions that talk about designing systems in terms of services and processes, but I think that the great emphasis here is on content, is on policing the content, criminalizing certain new behaviors, or just bringing in other criminal offenses from other legislation into the bill, just to fix all the burning societal issues that we want to fix as they emerge, in a certain moment. And I think that's a very wrong, non-systematic approach.
So Bima, would you like to respond, and then I'll turn to Will?
Yeah, no, absolutely. And I think you've raised so many different issues. I mean, first of all, about 2-3 years ago, I had a conversation with someone from the NCA, and they said, if I never had another CSAM complaint, that is a child sexual abuse complaint, it would take me 10 years to get through the backlog. So I do ask myself, and that was before we saw, 1,000% during COVID, and So I do ask myself, and I will be asking the government, what plans do we have to resource all these illegal things that we've just suddenly created? Yeah, that's one question. And secondarily, I am actually going to see whether I can put forward an amendment, I'm publicizing it here now, to have a review, after the bill has passed, to see what impact it had on that kind of illegal activity. Because, I am concerned about making things illegal, going off to the next piece of legislation and wondering whether actually it either worked or is being resourced in a way. Which leads me to another problem, which is I'm generally uncomfortable about making individual things illegal. And I did actually, probably contrary to many of you on this call, in the conversation, prefer a duty of care, that we could have actually worked out what the baseline was, over a period of time in the courts and so on. But I preferred something broader, less specific, and more iterative, and say, is this product fit for purpose? You said it was going to do this, but actually look what it's actually done. I preferred that approach, because what we've ended up with is a sort of a gradual adding of individual things, and one of the things, for example, an amendment that went down today, so it's in the public arena, is to have a code about violence against women and girls. And actually, I have added my name to it. But you know, what does that mean for other groups that are not represented? You know, I find it very problematic, but in the absence of clause 11, in the absence of a general duty rather than a general monitoring, you know, a general duty, I think we've got ourselves in a problem of there's lots of things we don't quite like, and they're all coming back into the bill. I think the other thing that I would just say, you know, be mindful of, you know, this user to user doesn't really include machine generated material, and that is the big growth area. What are we going to do about that? Have we got a bill that's looking forward, or is it actually looking at a couple of companies in its sights over our shoulder and trying to fix the problems of the past? And then the last thing, which I say is a bit of a challenge to all of those who perhaps were less keen on the duty of care, you know, this idea of the toggle, you know, the third shield where you as a user can turn off things that are distasteful to you. Well, first of all, it seems to me we've thrown back away from Parliament, and I did agree with everything you said about parliamentary oversight, and there will be a move to have a standing committee and oversight and all of that. But you know, we have rather thrown away thrown away our power and given it back to the companies and say, you tell us what's distasteful and we won't see it. And as someone who is regularly abused online, I would just like to say, not seeing my abuse does not mean I am not abused. Yeah, I don't see it. I choose to opt out. That's my problem. But, you know, my kids, my colleagues, the people who the politicians I go to meet, and they Google me and see what, you know, they see who I am and they see all this stuff. So I just think that we have not had a very good conversation about this. We've had a very aggressive binary conversation when there was actually something about, you know, we've got a new world order, and let's stop pretending these companies are not mediating the outcome. And we should be looking at that really in a different set of, with a different set of eyes than, unfortunately, the ones we've ended up with. But on the very specific points that Edina just made, I couldn't agree more. And I hope that myself, my colleagues will start to look at some of those things.
Will, you raised your hand, please.
So many interesting points, and I won't take all of the debates, but 2 quick points. You raised this challenge of can the Secretary of State seriously be expected to come back to Parliament every time the Secretary of State thinks there's something on the internet they don't like. I paraphrase slightly unfairly. The answer, of course, is yes. I think it's an interesting contrast that since 2003, which is the last time there was a Communications Act, and that didn't mention the internet, by the way. Since then, we'd have had almost 20 immigration acts, and nothing that tries to grapple with how the internet is changing society in 20 years. Now, what we have argued is that we do need an iterative approach, as Baroness Kidron argued, not one big bill, but actually the build-up of a body of law over time that tries to tackle specific, well-identified problems in a principled way, rather than create a framework through which everything can be solved. And I think that's one of the fundamental flaws of the bill. What the bill actually does is often exaggerated. You know, it's mostly about risk assessments and transparency and so on. You know, it doesn't have some of those direct levers of the government says this and the internet companies do that is sometimes implied. But nonetheless, we think the targeted build-up of a body of specific law over time would be a better approach. And actually, we should see Parliament year in, year out legislating in this area, but in small incremental ways that build up the expertise within Parliament to actually legislate intelligently about how this is all changing our society.
Great, thank you. I want to remind viewers that you are free to submit a question to the panel. Please drop questions into the Q&A box, but I'm going to press on with my moderator's privilege to ask one more question before we can look into the inbox. And I suppose it's a question mostly for Bevan and Will, but Edina and Matthew, please jump in. One of the concerns I suppose I have of the bill and others is that the bill may introduce an incentive for firms to remove valuable content, because oftentimes the harm of particular content rests in its context, not the content itself. So whether it's disinformation or suicide or content, there are instances where education about suicide or disinformation would use content in an education context. And I would be interested in the panel's thoughts on, does the bill do a good enough job of appreciating those nuances? Because I wouldn't blame a firm looking at the bill now and feeling as if they have an incentive to remove anything associated with potentially harmful content, even if it does mean that educational or medicinal or other helpful content is taken down. So I don't address that to any speaker in particular, but if you have thoughts on that, please jump in.
I mean, it's something we are already effectively looking at today. No, we ban anybody under the age of 18 from being able to download any Matrix clients, and we get about 20 email a day from upset kids or typically upset teachers in schools saying, hey, we actually want to have a secure way for our classrooms to communicate, particularly in the pandemic. Why can't my kids install your app? And we say, well, actually, we're concerned about legal risk of people discovering bad things out there. Originally, we thought the Online Harms Act, as it was sounding quite constructive in that it was addressing the problem that Beben outlined earlier about discouraging the big tech companies from addicting their users to abusive material, whether that's addicting children to abusive stuff or, heaven forbid, adults getting hooked on weird conspiracy theories or whatever it might be. And the wording when it was saying, hey, companies should take reasonable measures to protect their users from abusive, illegal content, I mean, it was very fuzzy, but at least it was fairly flexible in terms of how you would go about doing that. And as it happened, we were already working on a technology more sophisticated than the third shield toggle that Beben mentioned earlier, which effectively allows people to subscribe to whatever we call them reputation feeds, but basically editorial feeds of content that they might want. So if they don't want to see not safe for work content, then they subscribe to a list of not safe for work stuff and they tune it down. Or if they don't want to see Trump, they might dial him out. Or if they want to not go to jail for having CSAM content on their machine, then obviously they might subscribe to a block list of CSAM content published by IWF or NetMech or however it might be, and go and block it out. And so you effectively provide the technical infrastructure for the users to be able to tune the algorithms as they like. And obviously that can work in reverse and allow the bad actors to find the bad content as well. But it feels like a much more principled approach to empower the users and the communities and the server admins to do the right thing, rather than go after the content and undermine everybody's privacy. So I think we've completely thrown the baby out with the bathwater on this by focusing on content, not looking at fixing the underlying systems and problems. And it's very frustrating that what could actually be quite transformative in terms of forcing the big tech companies to be responsible just ends up being a massive privacy human rights violation. And I really hope it's not too late for the House of Lords to intervene on it, because this feels to me the sort of precisely the thing that the Lords should do, looking on behalf of society as a whole and the individuals who are going to end up with a CCTV camera basically built into their phone for the rest of time to intervene. Sorry, that might not have been a direct answer to your question.
I'm not going to speak for all the Lords specifically because I'm a crossbencher, but I think, I think we're very minded to look at a lot of this, but, we are, for very good reason, the second house, not the first house, and you might need to persuade some of the folks at the other end to support the amendments we make. I just want to sort of maybe put something on the cards that is a half answer, Matthew, to what you're saying. I mean, one of the things that went out with the clause 11 was the requirement to do a risk assessment. And actually, I think that all sides of this debate should push very hard to get that risk assessment back in, even if it is a risk assessment about your own terms and conditions, and illegal content. That unless there is a risk assessment, then what are we measuring against? We know that companies do it. And I'm sorry, I can't remember who said it, but the magical word transparency was mentioned in the last 5-10 minutes. And I think transparency it's not the only thing. I think some things actually should be mandated. Some things must not be allowed. But for the most part, transparency is our biggest tool for getting a settlement that will satisfy us all. And if I can, and I also think that there should be, effective routes to challenge. And I want to make 2 very sort of specific case study points there, which is, I was, in the Molly Russell inquest, and I have to tell you, the media box was full every day, and so was the visitors box, and everybody had an interest and expertise, had been covering the area for a very long time. And, at certain points, I look around the room and not one of them could believe their eyes. And I recently showed the same material here in Parliament to peers and MPs, and there were at least 3 ex-secretaries of state on DCMS in the room, and each one of them said, I had no idea. So the transparency of seeing what the issue was in an open court was as important, as the decision itself. So I think that if we have risk assessments that must be published, you start to see whether they're taking things down you don't like, whether they're taking a lot down, whether they're taking a little down, and equally, whether they are shoving a diet of rubbish at the kids, and when I say rubbish, I mean very, very serious stuff. And then the second thing, and I will just say that I have an amendment, that's coming to the bill, which is to allow coroners access to that material, because it took the Russells 5 years to get that. And I know at least 5 other families who have never seen the material that there was around the kids. And I think that this is a very extreme case, and it's hard to argue with it, but I think that if we had that on the more marginal cases, we would all be more comfortable.
Will, did you want to jump in?
Yeah, to echo Baroness Kidron on transparency, and let's be realistic, the internet companies have used their exclusive control over information about what's going on their platforms to shape this debate and limit the possibilities for sensible policy in this area. But to pick up your challenge about overreach, the overreach is already here, as I tried to make clear in my opening remarks. The bill is not going to create the overreach. The overreach is already happening. Content removal is very often the least politically sensitive, commercially sensitive option that internet companies have. So what you need, if you want to protect for freedom to impart and receive information, as Article 10 of the ECHR would put it, is positive measures in the bill to do that, not a belief that the status quo is actually currently protecting freedom of information, freedom of expression. The commercial incentives and the political incentives are not there for that.
Okay, thank you all. I want to turn now to audience questions. A reminder to viewers, please feel free to submit questions. I can see there's more than a dozen already, so I will apologize in advance. I don't think we'll get to all of them. But Andrew Livingston posed a question about something we haven't discussed directly, which is the age verification or assurance provisions of the bill. He asked says specifically, there will be huge incentive for companies to discriminate against sexual minorities or sex workers by removing access in the UK because age verification is implausibly expensive and unsafe. So I'll direct the question to the panel if you have thoughts on it. But I suppose it is a question about what the costs of some of the bill's obligations might be and the effect it has on firms. Would anyone like to answer? Yes.
I'll just on the, he also has another question about, sorry to do this to you, but about accountability of age verification. I just want to say, I really care passionately that we have rules of the road for age assurance. Yeah, we do need it. The technology is actually pretty grown up and getting good, but we have to say, you know, what the privacy standard of it is, what the security standard of it is, when it can be used and why it can be used, and that it's proportional to its use and so on. So that is, I'm afraid, I'm advertising all my amendments. That's another amendment I have with a lot of support from people all over the House. But I think in terms of costs, I think we have got a little bit hooked, and I do mean the big we, because most of us, you know, if you have a pension, you may probably inadvertently have money in the tech companies, et cetera, et cetera. You know, we've all got a little bit greedy, a little bit drunk, you know, on the amount of profit that these guys have in terms of their costs. And I think that some of regulating it will actually just simply be a cost of business. And, you know, I'm sorry to the other Matthew that, you know, some of the regulation will be a cost of building a new business. But I do think that this idea that only the big boys can pay is wrong. And I do think that the missing piece in our conversation is competition law, which should be much more robust, and we shouldn't be allowing the further entrenchment of a handful of companies.
Edina, you have your hand raised.
Yes, I think just briefly, I think there is an amendment by Lord Stevenson published to that effect that talks about the necessity to ensure competition, privacy, security, and other assurances for this technology. And I do share concerns with regards to the competition in the market, expenses, and the effects that might have on small businesses, startups, but also minority groups, as the question asked. So I think in the current state, the bill does raise these concerns quite strongly, and it should be amended if possible.
If I can hop in on the age verification thing. I mean, first of all, to be clear, my position here is more coming from a human rights perspective rather than a tech company perspective. I mean, who cares if some random tech company in Chiswick goes under due to this? I totally get that. But from the health of the species as a whole, how do you do age verification in practice? You have to go and prove a passport or whatever, and so people are going to need to somehow identify themselves back to the human identity, and you've destroyed anonymity. I see Beben shaking her head, so I may be missing something here.
No, I mean, there's I absolutely agree. People shouldn't have to identify themselves, but I mean, you can actually have a code, a token establishing age. You may have to establish age somewhere in order to get the token, but it may be in context that you're perfectly happy, like your doctor, your post office, your school, etc., etc. What's important is how that information is shared, transferred, and so on, and that it is separated from being ID, which I violently oppose.
Okay, that makes sense. I hadn't thought of using verifiable claims, which is what the techies, I think, would describe as a kind of opaque token that doesn't link back to identity, but just says, hey, somebody trusted has vouched that I'm indeed over the age of 18. However, by going and putting that as a requirement to participate on a service, obviously there's going to be costs in terms of then the economy, which pops up, of resellers of verifiable tokens to make sure that you've gone and paid your 10 quid for somebody to go and vouch that you're 18 plus or whatever it might be. But also in the context of the internet as a whole, you're suddenly starting to create these sort of very regulated subsets, these almost private, you're fragmenting the internet itself if there are services which you can only use if you are, again, a good actor and you've proven that you are over 18. And the thing that really frustrates me is that, again, the bad actors or curious kids are just going to go and install the apps which don't uphold this. I mean, it's a leaky sieve in the extreme. And I can remember myself, age 15, 16, messing around on the very early internet and finding all sorts of terrible content on news groups, etc. And you know, if there had been a sort of a nanny state protection put on it that says, hang on, you're only allowed to use Facebook if you've got the token that says you're over 18, I just ignored it. And I think it's almost going to push people more into the underground that already exists and you can't get rid of in order to find the naughty illicit stuff, because that's kind of what particularly kids like to do.
I don't want, you know, I know this is a broader conversation, but I actually have to say two things really that are just wrong-headed about that. You know, one is that actually it's fine if people are curious and it's fine if they know, but it's sort of almost like knowing that you are transgressing, knowing that you are seeking, knowing you're reaching to the top shelf. All of that is actually very important for child development. Being an 8-year-old kid and being sent massive amounts of, you know, hardcore porn. So the first sex you see is not the kiss, but the gangbang is problematic, and it is problematic. And I can show you all the material, you know, from, actually, I won't say it in public. It is just sort of horrific. But so I think there's let's not pretend this is curious children. Curious children will always do, and you know, in my view, fabulous. Let children be curious, and if they also get a VPN and go around and so on, they're also having digital skills. All good. I think the other thing is, I go back to my point. We're not talking about kids going to Wikipedia. We're not talking about kids going on Pornhub. We're not talking about this. We're talking about what then follows them and pushes them. And so that's the bit. And I think that there is a use of, you know, and I'm a bit frustrated because every time I go on, I have to give my, you know, my age, my number, my credit card, my finger, my face, my this, you know, to do anything. And then when it comes to age, everybody's up in arms. So I think that we have to be a bit more realistic about the way that all of our identities are required, used, shared, held. And what I would like to see is to make sure that anyone purports to check age, that they do it in a way that is privacy preserving, not commercially intent, and as much as possible has an interoperable quality, so that actually, you know, we don't end up with the stickiest web in the world. But again, I'm going to finish with what I started with is, we're not on this alone. This is happening everywhere, and we are going to have to bubble up to some sort of consensus that this one web thing isn't working, because guess what? We're just about to get an online safety bill which has toggles in it. So we're all going to have different words, which I don't like any more than you do. So, you know, it is fragmenting in different ways. And a lot of our public space has indeed become privatized, you know, in various hidden forms. And I think that that's also problematic.
Okay, thank you. Sorry, I will plead guilty to being rather poor at time management with audience questions here. My apologies. I know we're in the final 3 minutes here, but what I would like to do is to offer each of the panelists in the last 3 minutes, 30 seconds to a minute of closing remarks, and then I will wrap up the webinar. So maybe we could start with Will, go in reverse order as we started.
Gosh, well, it's a lot, isn't it? I think the fundamental point I'd bear in mind is that internet companies have tremendous power to shape our society. That power is novel and poorly understood. The one thing we must get out of this bill is better transparency to provide a better understanding of that power, so that we can gradually evolve policy that holds that power to account in sensible ways. What I would like to see us get out of this bill is a proper open society response to misinformation that pulls back some of the overreach that is currently going on and provides an open, democratic, transparent process for tackling misinformation that is truly proportionate to the harms that exist.
Thank you. Bevan?
Really just a plea for a sort of support for transparency, because I think that's the part of the Venn diagram we can all agree on. And I think without it, it will be a heavy bill with less or little purpose.
Edina?
I would agree with regards to transparency, and just going back to Will's point, I think what what he was talking about is the very powerful companies, but what we endanger here are small companies and startups, you know, and this innovation that the government is promoting on the one hand, and then on the other hand, endangering and infringing potentially user rights, not just freedom of expression, but also freedom of thought, potentially privacy, data protection, all sorts of rights. If the bill is imbalanced, I think the bill is, as I said, fundamentally wrong at the beginning, but I think there are ways to improve it, and I did mention some of the clauses that I would like to see amended in the Lords, and I hope that will happen. Thank you.
Matthew?
I think we're basically standing at a turning point for the future of civilization, let alone humanity and the internet, in terms of whether we are literally going to end up putting a CCTV camera into everybody's phone to catch people if they are doing bad things, which is currently the direct requirement for the safety bill. I cannot believe that we've ended up in this Orwellian situation. And I agree that we should hold companies accountable if they abuse their users and addict them, and if they follow them around the internet with abusive content because they look for something. But the answer to that is not blanket surveillance. It's going and spotting the companies who are doing that and figuring out a way to hold them accountable. And so more than anything, actually one final point is that the reality of what will happen is I think people will move towards peer-to-peer communication systems. We already have one built on Matrix, where there aren't any companies involved anymore. There aren't any servers involved anymore. You install an app, it's kind of the Bitcoin equivalent, but for communication. And suddenly it's just the user who will be accountable for who they communicate with. And it will become completely impossible to regulate unless, of course, the phone is spying on you, as Apple is proposing. And that, I mean, I guess is probably the most likely outcome in the longer term. So it will end up being a completely unenforceable chunk of regulation anyway. Unless, of course, you convince the Googles and the Apples to spy on everybody. So let's please not create that dystopia. This is, and it scares me that this isn't getting more attention from the world press, because, as we have said, it's the entire world who is looking at regulation around this right now, and we could be setting a precedent across Ireland and the UK and the EU where privacy is no longer a thing in our technology stack. It's unbelievable.
Well, thank you all. As the audience, I'm sure, is aware now, if they weren't before, this is a very big, complex piece of legislation, and there'll be more discussions going forward. I would urge everyone watching to check out the four panelists' work, a lot of it online. I myself, a final plug, have written about the online safety bill at Center for Policy Studies. So please keep an eye on CPS as we continue to do more work on this. But I'll just conclude by thanking all of our speakers, providing a great, I think, diverse set of views on a complex and challenging piece of legislation. Thank you all for giving us an hour of your time. Thank you.